majority of my work is in the field of surrogacy and assisted reproduction. And I'm going to talk to you about parental orders, which hopefully you will have heard of because they're very important if you can get them. But I'm also going to talk about some of the other legal issues that arise as a matter of UK law, both in the context of domestic surrogacy and also in international surrogacy for those of you who are considering surrogacy overseas. The law in the UK is applicable regardless of where your child was born. So in many destinations internationally for surrogacy, the intended parents are recognised either pre-birth or shortly after birth as the legal parents of that child. That means that a birth certificate can be registered with the intended parents named on it, and you can come back with a birth certificate and say, well, my child was born overseas, therefore I'm the legal parent, but that's not correct because UK law does not recognise those documents as being indicative of the legal position in the UK. In the UK, the legal mother of the child is a surrogate at birth. If the surrogate is married or in a civil partnership, then her spouse or civil partner is the child's second legal parent, and under UK law, a child can only have two parents. Working out who the legal parents are at birth is very important because it has implications, particularly in the context of international surrogacy, in terms of whether you're going to be able to get a UK passport for your child. You may not need a passport straight away if you've gone to a destination, for example, the US or Canada, where you can get a US or Canadian passport, but you need to know what the position is because there may be visa issues for entering the UK, and you need to regularise your child's status in this country as a priority when you come back. And in other countries, for example, the Ukraine, Russia, Greece, you're not going to get a local passport, you're not going to get a Greek passport, you're not going to get a Ukrainian passport for that child, so you need a document that you can travel on. So there is a greater urgency in those circumstances to regularising the position. So what if your surrogate's not married, then the biological intended father is the legal father under UK law, although they don't necessarily have parental responsibility. For immigration purposes and international surrogacy, that means that if the biological intended father is British, they can pass on British citizenship to the child, and that is one less hurdle that you need to get through. So you need to consider immigration issues, particularly if you're looking at international surrogacy as a priority. And then other issues of legal parentage. So what are the issues of legal parentage and why does it matter? Well, from a family law point of view, I'm a family lawyer, medical decisions, education decisions, those are all decisions that with parental authority derive from legal parentage with parental responsibility. But it also has citizenship issues, inheritance issues, and there are some pension issues and some pension policies in terms of entitlement and that right. So legal parentage is important to establish in the UK under UK law. And a parental order is the bespoke order for doing that for those of you that are eligible for a parental order. Parental orders apply equally in domestic and international surrogacy cases. In a domestic surrogacy case, your parental order will normally be heard at a lower level of judge in the family court, so most domestic parental orders are heard by magistrates. International surrogacy cases are currently all heard in the family court by high court judges. Okay, the same law is applied, or the same law applies. There is varying levels of degrees of how strictly, in our experience, the magistrates certainly apply the law. I tend to think that it's not always clearly followed in the magistrates' court as it is in the High Court. So what is a parental order, and what do you need to do in order to be eligible, or how are you eligible for a parental order? A parental order makes you the legal parents of your child. At the moment, an application for a parental order needs to be made by a couple. You don't need to be married. You can be in a same-sex relationship. You can be married, but at the moment it's an application by a couple. There was a case a couple of years ago now which challenged that on human rights grounds, and the government was joined as a party to those proceedings, and the government conceded that the requirement for a parental order to be applied for by a couple was incompatible with the European Convention on Human Rights. The result of that is that there is currently a draft legislation called a remedial order that is before Parliament at the moment, with a view to allowing single parents with a genetic link to apply for a parental order. At the moment we don't have the timescales. We're hoping at some point this year. Certainly people starting the process now can have some confidence that there is going to be a parental order available to them immediately afterwards. But even in the draft legislation, if the parental order isn't available, there is a 6-month window for people who weren't previously entitled to parental orders to come back and make the application. So another requirement for a parental order is a genetic link. There has to be, in order to get a parental order, a genetic link between the child and at least one of the intended parents. And by genetic link, I mean a direct genetic link, i.e. a biological parent. And that is important under our legislation. At the moment, you can't get a parental order unless you've got that genetic link. And that's certainly something that you need to be aware of if you go overseas to a destination where, for example, you may not require a genetic link, because that is going to have implications for immigration issues back home in the UK. So if there is a situation where you're not going to be genetically related, or neither of you are going to be genetically related to the child, you need to take specialist immigration advice before you start that journey, because that could impact on how you're going to bring the baby home. Applications for a parental order need to be made within 6 months of the child being born. There are cases where parental orders can be applied for what we call out of time. So if you miss the 6-month deadline, it is no longer fatal to your application, but it's certainly something that you need to be thinking about, and it is far easier to get the parental order if you make the application within those 6 months. Your surrogate, and if she has married her spouse or civil partner, has to consent to the making of the parental order. That's a mandatory requirement. In our statute, there are very few exceptions, which is if you can't find your surrogate, or if your surrogate is incapable of giving her agreement. But if something were to happen, and I've certainly dealt with cases involving surrogates where relationships between the intended parents and surrogates have broken down, not to the extent that the surrogate changed her mind, but certainly to the extent that changing her mind in terms of wanting to keep the child, but changing her mind in terms of wanting to assist the intended parents acquire parentage. In those cases, unless the surrogate agreed through mediation or through processes, that created huge difficulties. So we have to make sure that your surrogate consents for the parental order to happen, to be made. You've got to be domiciled in the UK, or at least one of you has got to be domiciled in the UK. For those of you who were born in the UK to British parents and lived in the UK your whole life, that's probably not going to be an issue. For those of you that maybe were born overseas, maybe overseas nationals living in the UK, that might be... We might need to work around it, or you might need to work around to see if you can fit within the legal definition of domicile. It's effectively the law that applies to you. It's where you intend to live, effectively. But it is over and above residence. The main issue in most surrogacy cases is the issue of payments. UK law, we say UK law allows only altruistic surrogacy. It's actually not an offence to make a payment to a surrogate, or for a surrogate to receive a payment that exceeds reasonable expenses. The offences relate to third parties that get involved in the process. So although we say we don't allow commercial surrogacy in the UK, it's a bit of a misnomer really, because it's more against public policy rather than against the law unless you're a third-party facilitator like a lawyer or an agency getting involved in the process for a fee. But if you make a payment that exceeds reasonable expenses to a surrogate, you have to ask the court to authorise that payment. In reality, this means setting out the payments that are have been made under the surrogacy arrangement and breaking that down from expenses and identifying what is an expense and what is a payment. In most international surrogacy cases, your arrangement will be considered to be commercial by the English court. Some Canadian arrangements, in Canada they only allow altruistic surrogacy, but it depends on the nature of the payment. And for example, in California, you might see that a surrogate has a base fee of maybe $30,000 to $40,000. That is a fee that you pay the surrogate for her gestational services in the contract. That is her fee. And that is what you have to ask the court to authorise. So you need to demonstrate what's been paid. And that might be from producing the escrow account ledger or the trust account ledger that exists in the US. If you're making payments directly, it's a good idea to keep a documentation of what's been paid so you can produce bank statements showing all of the payments made. You calculate that sum and you ask the court to authorise it. There's not been a case yet where the court has failed to authorise a sum of money. And that's because the court's primary consideration is the lifelong best interests of the child. Parental orders in the UK are post-birth orders. By the time they get to a final hearing, the baby has been living with their intended parents for normally a few months, 5-6 months, and the surrogate, because it's a consent application, doesn't want to care for the baby. So the court is either going to leave a child without legal parentage with their psychological and often biological parents, or they're not. And so it's a very easy welfare argument to run to get the court to authorise those payments that have been made. The other issue is you've got to be over the age of 18, which is fairly straightforward. In terms of the process, the court process that takes place in England, like I've said, if you've got an international surrogacy arrangement, your case is going to be in the High Court. You can issue in your local court, and your case could be heard in a local High Court registry, but most surrogacy cases are heard at the High Court in London. There are normally 2 court hearings, and the court, when you issue an application, will allocate a court welfare officer with CAFCAS, which is the Child and Family Court Advisory and Support Service, whose role it is to independently assess the welfare of the child and to also assess the criteria for parental order and check that that criteria are met. They will make an appointment to come and see you and normally spend a couple of hours with you talking to you about the arrangement, your relationship with your surrogate, and they're interested in knowing how you intend to tell the child about surrogacy and whether you're going to have a relationship with your surrogate in the future, and if you've used an egg donor, how you're going to raise those issues with your child. If you've got a domestic surrogacy, the parental order reporter also obtains the consent of your surrogate. So in domestic cases, they will often make arrangements to meet with or at least speak with your surrogate. If geographically you live in Cornwall and your surrogate lives in Newcastle upon Tyne, it's not likely that your CAFCAS officer is going to travel to meet, but they may ask a local officer to go and meet with them. But in international cases, they don't do that for obvious logistical reasons. So for the consent for international cases, the standard forms of consent are notarized by a notary public in your surrogate's home country. So that's really the process. Normally 2 court hearings, occasionally 1 court hearing if you have a really helpful CAFCAS officer that can undertake their home visit before the first hearing, which strictly speaking they're not meant to, but it's really helpful when they do. And the process itself is it's designed to allow people to become parents without using adoption. it's not there to trip you up. So if you're entitled to a parental order, it's certainly something that you should get, or certainly consider getting, and to seek, because issues with parental order, if issues arise when people don't get parental orders, when things go wrong, and you want to make sure that you have that order at the outset to secure your child's best interest. If you're not entitled to a parental order because, for example, you're not domiciled in the UK, or you're not in a couple, or you don't have a genetic link, there are other kinds of orders that can be obtained under our family law orders, general principles under the Children Act and other statutes that exist in England to give you parental rights. You certainly want to get orders that get you parental responsibility so that you have decision-making powers in relation to your child. You'll often see, if you do research, particularly in relation to parental orders, when Parliament were discussing whether or not certain people, for example, people without a genetic link, could get a parental order, they would say, oh no, they could do adoption. They said it in relation to single parents. Adoption is not something that is straightforward in the context of surrogacy, particularly international surrogacy, because there are lots of criminal offences that apply in adoption aimed at dealing with inter-country adoption, ensuring people comply with the various inter-country adoption regulations, which don't work in the context of a surrogacy arrangement, but they still technically apply if you strictly apply the laws. And at the moment, although the courts have highlighted these difficulties and have sent their judgments to the relevant governmental departments to recommend that they do something about it, it seems to have fallen on deaf ears. So at the moment we're in a bit of a limbo about those things. But certainly adoption is a possibility in theory if you're not able to get a parental order. But it is not without its difficulties, and it's certainly something that you need to be aware of before you go into your process. If you're at the early stages now, in terms of thinking, well, do I want to go overseas, or am I going to do surrogacy internationally or domestically, think about what you're going to do to bring your baby home and how you're going to get those rights. Have a plan. Make sure you take advice from people who know what they're doing. A lot of general family lawyers are not specialists in this particular field, and they don't always give the most accurate advice. Also, if you're going overseas, make sure you get some immigration advice or research the position on how you're going to bring the baby home. It is much better to do that planning before you enter into the process, before you commit, before you've got a pregnancy, rather than, as everyone who practices in this field has come across, people calling you up saying, my baby was born a month ago, I kind of want to get home, I don't know how about getting home from the Ukraine. And you say, well, okay, well, you've got a 90-day visa and you've got about 4 months to wait until you get a passport, so you've got to get moving. And they've not made plans because they were expecting to come home. Certainly make sure you get the advice and do your research well in advance, so that you know what you're going to do and how you're going to do it and how you're going to get your baby home. Because surrogacy is it's a lengthy process, and you want to do everything you can to minimise the disruption, particularly when you've got a new baby.